in the former TBVC states, i.e. that being the Transkei, Bophuthatswana, Venda, and the Ciskei. The court ordered that Parliament must remedy the defects in the legislation. Having published a call for submission of comments on the amendment bill, the Portfolio Committee on Agriculture, Land Reform and Rural Development received 35 written submissions, mainly from organizations and a few from individuals representing communities. The Public Education Office and the Parliamentary Democracy Offices ran awareness campaigns on the bill. A total of 481 individuals, representatives of organizations, and community leaders showed interest to address the committee. The Secretariat therefore confirmed 110 people to make oral submissions. The remainder are people interested to follow the proceedings, those with complaints about land restitution claims, farm evictions, and allocation of plots. Many of those were encouraged to submit their concerns to the committee in writing. And I appeal to all honorable members as well as our guests that have logged on to mute their microphones. We can hear your conversations, and we would like to request that you mute all your microphones so that we can be able to have smooth running of today's affairs. The committee was also encouraged to tune into different platforms such as the Parliament's DSTV channel on 408, YouTube, Facebook, as well as Twitter. Some of those may be able to join the committee on these platforms. As the program shows, it is impossible to fit in everyone today and tomorrow's program, as we've had many submissions. As discussed during the previous meeting, there is a need for an extension of public hearings. The committee will need more or less about 2.5 days during the week ending on the 28th of August 2020 to listen to community members that would like to have their voices heard. For today and tomorrow, the committee will listen to 24 substantive presentations from lawyers, academics, researchers, leaders, and representatives of civil society organizations. Each presenter, honorable members, will be allocated 20 minutes, and after 3 or 4 speakers, the committee will be allocated time for questions of clarity and comments. It is not a must that members of the committee must ask questions if not necessary. However, critical engagement with the input by the speakers is vitally important. We will therefore only be entertaining only clarity-seeking questions just to gain more or in-depth understanding of the presentations. But the rest of the discussions, honorable members, we will leave for the committee at our own time to be able to deliberate and engage on those matters. We therefore would like to welcome everyone to this morning sessions, and we will then request the presenters to present as their request. Let me then look to the Secretariat as to the program that has been put before us, honorable members, for us to be able to take on to the first presentations. Mam Kakaza, Manyamza, can you please indicate as to who are the first presenters?
Thank you, Chair. The first presenters are Ms. Nokwanda Sihlali and Gudimlungis. They are from UCT. But the only thing that we need to do before we start, Chair, is to agree on the extension of the new dates for oral submissions.
Okay. No, then I was going to leave that for later, but we can as well just dispense of the matter right now. Honorable members, having had for the extensive submissions that have been made, we are of the view that we should be able to apply for an extension for 2.5 days to be able to hear the other submissions. Let me put that to the committee as to gain support in that regard. Honorable Tape.
I agree that that application should be done for extension.
Thank you, Honorable Tape. Honorable Kapa.
I'm in agreement with the application for the extension, Honorable Chair.
Thank you. Honorable Mestein.
Thank you, Chairperson. I totally agree. I would also like the Secretariat to give us the list of all the people that were that they were interacting with, and then just to get some clarity on how the decision was taken on which 110 or how many people will make the oral submissions. Thank you, Chair.
Thank you, Honorable Stein. Honorable Matthias.
Morning, Chair, and morning to members of Parliament, colleagues. I agree, Chairperson, and it would be important to know whether our core constituency, among our core constituencies who have submitted the presentations, it would be pointless really to continue if not knowing whether our core constituencies have made presentations and have made in the final list of presenters. Thank you, Chair.
Yes, thank you, Honorable Briet.
Thank you, Chairperson. I would like to concur with Honourable Stein. I would agree, and I would like to have those lists just to so as suffice and satisfy us. Thank you so much.
Thank you, Honorable Briet. Honorable Matlatsi.
Thank you, Chair. Let me also greet colleagues. Morning, everyone. I agree with the extension, Chair, but I just wanted to check if the dates that the number of days that have been suggested, will they be sufficient for the number of people who will be participating, so that we don't just drag everybody in one day, in those 2 days. If possible, like we had initially requested, that at least let it be for a week, can we just reassure the secretariat reassure us that it will be sufficient so that we don't leave anybody behind? But I agree with the extension. Thank you very much.
Thank you, Honorable Chwete.
Thank you, Chairperson. I agree with the extension. Also agreeing with the honorable members that we should be finished with the list of the stakeholders. Thank you, Chair.
Thank you, Honorable Mbabama.
I have no objection whatsoever, Chair. I agree.
Thank you, Honorable Masipa.
Morning, Chair, and morning, colleagues. I do agree fully with the extension, and however, I'm also appealing that we must also make sure that all constituencies are covered, because I think 2 days will be too little. Thanks, Chair.
Thank you, Honorable Muntwedi.
Honorable Chair.
Yes.
Honorable Mtuedi is struggling to lock in. He's in Freiberg. Freiberg is a rural, is very rural. He's struggling, but he will be joining us later.
Okay. Now, thanks for that, Honorable Matthias. Honorable Mbata. Any other honorable members that I have missed?
Honorable Mahlo.
Honorable Mahlo. Mahlo. Okay. Perhaps she's also having challenges with the network. When she joins us, we will be happy to hear from her. But honorable members, let us appreciate your support and agreement that we proceed with the extension to apply for the 2.5 days that have been indicated. As the management committee, we have been receiving the submissions through the secretariat, and from the submissions that have been made, we have been able to look at the dates and also look at the number of days that would be required. And this is solemnly informed with the submissions that have come in that we have been able to allocate 2.5 days. Should there be more applications or submissions made, we will then need to relook into that. But let me hand over to the Secretariat to give us clarity. I do know that all the submissions that have been made, we have them on record, and I would request that the Secretariat must make them available to all honorable members so as to be able to verify that all provinces were able to participate and all interested parties were also given an opportunity to participate. Let us then hand over to the Secretariat. Manyamza, Mamukakaza.
Hello, Chair. Yes, Chair, we will make all the submissions available. We did make all the written submission to members. The list of the submissions from the provinces will email to all the members based on the list that we receive from public education. Thank you, Chair.
Thank you. Honorable members, as indicated by Umamukakaza, we have received the presentations that will be put to us over the next 2 days. The only list that is still we are waiting is the list of There are other submissions made from interested individuals. So we will try and group those according to provinces, and then try and see as to how we can be able to have them linked so we can have those submissions put to us. Honorable
Chairperson,
yes.
Matthias here.
Yes, Honorable Matthias.
Yes, well, by core constituency, Chair, let me correct this point. We are not particularly referring to provinces. We refer to constituency in the context of African, predominantly African, Black in general, and working class constituencies. Would want to know, the reason why we want to have a list is to know whether organizations that would be making presentations are drawn or come from that core constituency. Not really province-based kind of constituency. Okay.
Yes, Honorable Matthias, do take into account that all citizens of the Republic of South Africa were invited to this public hearings through all forms of media. The communications team was all out, ensuring that we are able to get the word out. This is why we have had over 481 submissions made from across the landscape of our country. So we are certain that in terms of the interested parties, the word has gotten out, and we have been able to do extensive work in roping them into these public hearings. I therefore, honorable members, will request that we proceed with the public hearings as outlined by Manyamza. Manyamza, if I have it correct, you said that we are going to have Ms. Sihlali and Mr. Kanyeza.
Yes, Chair. That's correct.
Right. They are coming from the Land Accountability Resource Center. Let us then afford them time to proceed, and we will then look into the other presentations, and I think they will be immediately followed by Agri-SA. By the Legal Resource Center, Ms. Wicom, as well as a submission from Agri-SA by Ms. Annelise Crosby. Those are the three presentations we will take one after the other. Then after they've done, we will then go into questions of clarity. Mamusihlali, Notatu Kanyenza, you can proceed.
Okay. Good morning, everyone. I'm not sure if Ubab Kanyenza, okay, he's online. Greetings to the committee, to the parliamentary staff, my fellow presenters, and others in attendance. I'm going straight into the presentation.
Please, honorable members and our guests, mute your microphones, because we can hear everything that is picked up by audio. Please mute your microphones.
Okay.
Proceed, Ms. Lal.
Thank you, Chair. We would firstly like to thank the committee for the opportunity given for our organization to make an oral submission on the Ultra Amendment Bill. My name is Nokwanda Sihlali from the Land and Accountability Research Center. We're based at UCT. I will be co-presenting with my colleague, Mr. Mlungisi Kanyeza, who is a member of the Dinabagubo Residents Association. I know that it's Women's Month, and there was an expectation possibly that I presented my own, but I would like my colleague to also be with me. I'll go straight into the presentation. LARC would like to congratulate Parliament, more especially this portfolio committee, for moving forward with attempting to implement the judgments of the Constitutional Court aimed at securing the tenure rights of the most vulnerable and marginalized South Africans through legislation. It is so important for the various arms of the state to work together in protecting the rights provided for in the Bill of Rights. It builds confidence in our constitutional democracy that when legislative gaps that threaten constitutional rights are identified, steps are taken to remedy the potential for rights violations. The objective of the bill is to allow certain rights in the land that were systematically weakened and undermined by the apartheid government to be upgraded and converted into ownership. This was a pre-constitutional attempt to reform the tenure framework to which Black people were limited. In principle, the aims of the Act are in line with the tenets of the Constitution and government's National Development Plan of dealing with landlessness and restoring the dignity of those formerly oppressed. In the previous committee meetings, the committee has expressed apprehension at moving too hastily with finalizing the bill without having explored in depth the parallel implications for existing and intended land reform laws and policies. LARC is in full support of a holistic approach to dealing with Ultra and its various shortcomings. A piecemeal approach would allow for further rights violations and is resource intensive. A holistic approach would enable the gaps that threaten the rights of vulnerable people to be identified sooner rather than later and immediately fixed. And people would need to wait, instead of people having to wait for expensive and protracted litigation to have their constitutional rights vindicated. Because of the Rahube judgment, Section 2.1 was declared unconstitutional, which means the conversions of tenure rights will no longer be automatic. The amendment bill now provides that potential rights holders make an application to upgrade their tenure rights to the minister for consideration. However, the proposed amendment of Section 2 of Ultra raises a number of issues that need to be dealt with before the adoption of the bill to ensure constitutional rights are not violated. The amendment bill places the obligation to deal with the applications for upgrading rights and the function to institute an inquiry into the facts of an application or objection on the minister and the department. This raises questions about whether the minister and the department have the resources and, most importantly, the capacity to deal with both processes. The department, especially with the addition of agriculture to its portfolio, is incredibly understaffed and under-resourced. In addition, the department's budget has been severely impacted by its COVID response. The amended Section 2 requires that the application be made in the prescribed manner. However, no detail is given about what the application process should look like to ensure constitutional compliance. If the intention is that the minister must adopt regulations or policies to articulate this, then the Act needs to make this unequivocal and give clear guidelines and timelines on the adoption of this process. Without a defined process set out or clarity on how this process is to be adopted, then the bill does not comply with the requirements of the Constitutional Court's order that a constitutionally permissible process be adopted to protect constitutional rights. The intended amendment requires that the minister only publish a notice about any application to upgrade rights in the Government Gazette. This is incredibly inadequate. A vast majority of the people that hold rights which Ultra applies to do not have regular or any access to government gazettes. A very deliberate approach needs to be taken to ensure that holders of vulnerable rights are able to easily access information related to processes that will irreparably impact their constitutional and property rights. In this regard, for example, at the very least, notices must be published in local newspapers in local languages. All these questions need to be considered and answered at this juncture to ensure laws aimed at protecting constitutional rights will actually be implemented properly. The amendment bill seeks to insert Section 14A, which provides an opportunity for persons aggrieved by the conversions that took place from the 27th of April 1994 to approach the courts for appropriate relief. However, the costs and resources that are related to approaching a court for any form of relief means that courts are inaccessible for a vast majority of South Africans, particularly the poor and marginalized persons to whom Ultra mostly applies. A more accessible, possibly community-based process is required that can appropriately take into account the resource limitations most South Africans struggle with. After fully considering the implications and operations of Section 3 of Ultra in the Senqu municipality matter, the Constitutional Court declared Section 25A of Ultra unconstitutional because Section 3 was not applicable to the entire Republic of South Africa. However, the amendment bill goes further than the court's decision. Section 25A of the Act has been amended to provide that, in addition to Section 3 of Ultra, Sections 19 and 20 also apply throughout the Republic. In doing this, the committee must then proactively and thoroughly engage with the history, operation, and implication of Section 19, which deals with the legal capacity of a tribe to obtain property, and Section 20, which deals with the transfer of tribal land to a tribe. Parliament must thoroughly consider the appropriateness of Section 19 and 20 and their implications for constitutionally protected rights in Sections 25(6) of the Constitution. Lark argues that Sections 19 and 20 of Ultra will have the effect of subverting the state's fulfillment of its constitutional obligation to give vulnerable South Africans secure tenure to land. These provisions do not include appropriate or adequate mechanisms to prevent the undermining of rights protected in the Constitution, the Interim Protection of Informal Land Rights Act, and customary law. Section 19 provides that a tribe can own land and, subject to Section 19(2), dispose of that land. However, no limitations on the valid disposals of land that had been transferred to tribes exist automatically, and no limitations or judicial oversight exists on the ability of a chief to dispose of tribal land. Section 20 sets out the process of transferring land to a tribe. There are no explicit provisions recognizing or protecting individual, family, group, or community rights. Rights that are recognized and protected again by the Constitution, customary law, and IPILRA in this process of transferring land to the tribe. No recourse is provided to anyone who holds property rights on the land that is to be transferred to a tribe, and should they be aggrieved by decisions in this regard. The Constitution, IPILRA, and customary law apply on the land these provisions of Ultra purport to regulate. IPILRA states that no person can be deprived of any informal right to land without his or her consent obtained in terms of applicable laws and customs. The impact of the operations of Section 19 and 20 as described above would be to deprive holders of rights recognized and protected by the Constitution, IPILRA, and customary law. As a minimum, IPILRA requires that a decision to deprive persons of their land rights be taken by a majority of the rights holders in a specifically convened meeting with sufficient notice and reasonable opportunity to participate. Ultra makes no mention of IPILRA and does not provide for protections that are at least equivalent to those in IPILRA. It is also unclear what the relationship between Ultra and IPILRA will look like in practice. Section 19 and 20 of Ultra undermine the fulfillment of Section 25(6) and any comprehensive tenure framework that the state may attempt to adopt. My concluding remarks. We welcome the amendment of the bill and the committee's commitment to addressing legislative gaps and following the Constitutional Court's directive. But this well-intentioned work risks being undermined by not ensuring that this is a methodical process with adequate public participation. We know that the deadline is the 20th of April 2021, but there needs to be engagement with corresponding laws and policies to consider also who will be affected. The examples that I've put at the table about access to the gazettes and access to the courts, to the court system. And we would like to encourage Parliament to not wait for another court case to deal with the important parts of the bill, specifically Section 19 and 20. I will now hand over to my colleague, Mr. Mlungisi Kanyeza, who will now give his personal account of the practical implications of Section 20 of Ultra.
You have 9 minutes remaining. 9 minutes remaining.
Yes, good morning. Thank you, Chairperson. Then yes, I'll start introducing myself. I'm coming from Guatinabagubo Residents Association. It's a community made up of about 400 families in KZN. I'll just give an account of these communities' history in respect of the injustice that take place regarding the issue of land. So I'll just go straight to it. My community was moved to make way for the construction of the Inanda Dam in 1987. I was 12 years at the time. I must mention now I'm 45 years. So you can imagine the injustice which has taken so long. The land was identified to compensate the members of the Ngolosi tribe that had been displaced by the dam, consisted of 250 hectares of agricultural land that was transferred in terms of Section 20 of Ultra to the Chief Beksisa Felix Bengu to hold on behalf of the tribe. It is for Parliament to deal with the practical impact and implications of Section 20 on the constitutional and property rights of the people who hold customary and other real land rights on the, especially it is intending on the expanding its operation. The Chief Beksisa and the Traditional Council have made a number of transfers of this land without notifying, consulting with, obtaining the consent of the holders of land rights and the people that were initially displaced on behalf of whom the land was held in trust by the chief. Land was transferred to the eThekwini municipality, and the purchase price of 3 million is reflected on the title deed. We were never told about this transfer, and we never gave our consent for this transfer. Land was transferred by the Traditional Council to a development company called Ngolosi Tribe Development Pty Ltd by way of a donation. Chief Bengu is the director of this company. We were never told of this transfer as well, and we never gave any consent to this particular transfer. Section 20 of Ultra has had the consequence of erasing the rights my family, as well as my community, have over our land after we were displaced from our traditional land to make way for Inanda Dam. We have not been able to get answers about how these transfers happened. We have approached the Department of Rural Development and Land Reform, COGTA, and the Public Protector to no avail. Whenever we ask questions, we are told that the owner of the land is Chief Beksisa Bengu, and then no questions can be asked, and that he can do whatever he likes because his name is on the title deed. We are just one example of what Section 20 of Ultra means for communities that hold rights to land that are already vulnerable. Our rights in terms of of Section 25 of the Constitution, our rights in terms of the interim protection informal land rights, and our land rights in terms of customary law have been and continue to be violated by the operation of Section 20 and Section 19 of ULTRA. That will be my conclusion in respect of the account regarding how we were victimized or deprived of our rights in terms of this section. So as the community, we would like to recommend that we are fully supporting the proposed amendments, because it will bring the appropriate balance needed between the exercise of power by a traditional council as well as the rights of the communities that are concerned. We like also to recommend to the committee sometime in the future to do a site visit, so that it can actually have a real account as to what actually happened and engage this community which has suffered as a result of this injustice. Thirdly, would like to recommend also to the committee to engage other state organs that we have mentioned with a view of finding out as to how far they have actually dealt with the matters, so that you can understand exactly the difficulty that we have experienced as ordinary people to try to have justice in respect of this matter. So I just want also to mention that as a result of this, there is illegal occupation that is taking place, which is in itself is adding another layer of complexity to resolve this matter. I thank you, Chairperson.
And that's the end of our presentation. Thank you so much for your time.
Masbulele, on presentation that has been put to us, honorable members, by Mamusitrali and Uta Tukanyeza. We will move on to the submission of Legal Resource Center, and we will then have Ms. W. Wincombe.
Good morning, Chair.
Good morning.
Thank you very much for the opportunity afforded to the Legal Resources Center to make these submissions. The Legal Resources Center is a non-profit public interest law firm. We've been around for 40 years, and much of the work that we do include representing poor rural communities that are affected by legislation such as this one. The LRC represented Mr. Tongwane and others in the Tongwane Constitutional Court judgment around the Communal Land Rights Act, and also Mr. Mwelase and others in another Constitutional Court judgment that dealt with the proper implementation of the Labour Tenants Act, where a special master was appointed. And so the submissions that we make today, we draw from the experiences of our clients, and in particular the challenges they faced with the improper upgrading and reform of tenure security still ongoing in South Africa. I want to start by saying something about the legislation itself, ULTRA, as it is colloquially known, and the context to that piece of legislation. As we know, and as the chair has reminded us, it is a piece of legislation from 1991. So it was adopted in a very particular context by the apartheid government towards the end, the dying days of that regime. And so it was adopted in a time where lawmakers were entirely insensitive to the realities and implications on the ground, oblivious to racial and gender discrimination, and entirely disinterested in how indigenous tenure systems operate and how to properly protect the tenure systems that were operating on the ground. And so Ultra was a last-ditch attempt, perhaps, to bring progressive legislation that would win the regime some clout, but it was done in a clumsy way. And as the Minister and the Director General told this committee on the 26th of June, when this amendment bill was presented, the intention was not for this kind of legislation to still be on the books, but be replaced by a comprehensive constitutional project of tenure reform that would ensure the tenure security of rural people in South Africa. That has not happened, and for that reason we still have this legislation on the books, and it is absolutely necessary to make sure that this legislation is indeed constitutional in its application. I would note that in the high-level panel report that was mandated by Parliament a couple of years ago, the report noted that there has been widespread failure to implement Ultra properly, and so the effectiveness of Ultra in protecting the people it was meant to protect and provide them with tenure security is in doubt, and it is important to continue to ascertain why that is the case. Now, as mentioned, there were two Constitutional Court judgments that make these amendments necessary, but I think the important point to make is these amendments are very necessary, in particular to the extent that they discriminate against African women, but they are absolutely not sufficient. So tinkering with old 1991 legislation is necessary, but it is not sufficient in providing proper tenure reform and tenure security, as Parliament should do in terms of Section 25(6) of the Constitution. And so while this is incredibly important for the committee to apply its mind properly to these amendments, let me implore you to continue to focus, as the department has told us they are doing, on a bigger project of tenure reform that will fully redress the insecurity and as is required. Now, I want to also emphasize, given how important this committee's task is, that in the Rube case, the one Concord judgment that led to this amendment, the Constitutional Court suspended their order of invalidity for 18 months, and they said they do that for a very specific reason, because the court is not in the position that Parliament is, to have the time and the space to conduct, and this is here I quote, the necessary factual inquiry to establish the full extent of redress required. And that is so important and expected of this committee, to understand exactly what the impact will be of this amendment, and whether that amendment therefore addresses the redress that is required. Now, in the opening remarks by the chair, he mentioned the objectives of this amendment bill, and in the socioeconomic impact assessment that was provided by the department to the committee, that objective is described as such. It says the amendment bill is specifically aiming at reversing the continued inadvertent sidelining of African females through asset poverty. And that is, of course, the case. That is what the Rehoboth case dealt with. Now, I want to immediately stop and point out that there is an amendment to this act that is never mentioned when the objectives to this amendment bill is described. It is not mentioned in the SEA. It was not mentioned by the chair this morning. And so it may well be that this amendment is being made inadvertently, but it is an amendment that will have an enormous effect. And for that reason, we must be extremely careful to make such an inadvertent amendment. And it's the one that my colleagues from LARC also mentioned, which is the amendment to Section 25A. Now, the court case, the Senku municipality case, that necessitated the amendment of Section 25A only speaks to making Section 3 of the amendment bill applicable across the Republic. This amendment bill goes much further by also making sections 19 and 20 applicable across the Republic. That is no court has considered the applicability of section 19 and 20, whether it's discriminatory, that it is not applying, and no court has found that it should apply across the Republic. Now, it's for a very good reason that those two sections do not apply across the Republic, and that is, as my colleague also explained, because we still do not have proper legislation that can protect the tenure rights of members and households living on communal land. Now, she's mentioned the Interim Protection of Informal Land Rights Act, another interim piece of legislation. It does provide some recourse for communities, but should this amendment of Section 25A to make Sections 19 and 20 applicable across the Republic go ahead, we would argue that the women living on traditional land would likely lose the protections that they are currently experiencing under IPILRA. And so what inadvertently may happen here is, while we amend this bill to strengthen the rights of women in terms of, sorry, I'm asked to switch off my video. I'm just going to do that. So while the objective of this amendment bill is to strengthen women's rights, rightly so, it may well be that making Sections 19 and 20 applicable across the Republic without the tenure reform in place that the department is currently working on will deny them those very tenure security rights that the bill aims to establish. Now, it is very important to note that the objectives of the bill and the SEA do not refer to making Sections 19 and 20 applicable across the Republic. It means that members of the public who hear about this bill and who hear about the contents of the bill, they do not understand that the implication of the bill goes beyond securing women's rights and goes towards allowing at the community level for ownership to be transferred. I should note that in the committee meeting where the Minister and the Director General presented this bill to this committee, Mr. Ndu Shaban specifically said that this bill does not deal with ownership at the community level. Now, that is not true. On the contrary, Sections 19 and 20 does exactly that. So it seems to me that it may be that this amendment is inadvertent. We implore the committee to not make Sections 19 and 20 applicable across the Republic in the absence of the proper tenure reform that the department has told us they are working on in terms of a proposed communal land rights bill. Now, we do want to say something about the other amendments, and in our submissions, we talk in some detail, as my colleague did, about some of the practical implications of those amendments that we are concerned with. We agree that a proposed remedy that the minister will publicize an application for a land tenure upgrade in the Gazette is unrealistic. We know of very few people who regularly check the Gazette and would therefore know that an application is in the process on the land that they regard as their own. We also do not see any details around the ministerial inquiry that will follow, and therefore it's unclear what the budgetary implications will be and how the department is going to implement this inquiry. We should also say that a proposed mechanism that centers the recognition and identification of tenure rights in the minister is perhaps out of step with realities on the ground. In addition to that, Ultra adopts the tenure system that was certainly reigning in 1991 and to a large extent continues to dominate our property system, which is that of private property rights that belongs to an individual person or entity. And that property model is very much out of step with realities on the ground. And so we would like to see the committee and certainly the department look towards a more bottom-up approach and look at local realities to identify and recognize tenure rights as they operate on the ground. Then we note in clause 3 of the bill that court applications are now also a possibility for people aggrieved by any decision by the minister. Again, we agree with our colleague from LARC that we must accept that court applications are very often only for those with the resources to bring such an application. Now, in this regard, it's very interesting. The two judgments that led to what the committee is asked to do here in amending the bill. The one is the Rahubi judgment, who's a lady who was lucky enough to be represented by a public interest law firm. And public interest law firms like ourselves and the Lawyers for Human Rights, we are able to take one out of hundreds of cases. So it doesn't solve the problem. The other case, the Marcus Eno versus Senku judgment, that was brought not by poor African people wanting to assert their land rights. It was brought by a wealthy white land trust. And so it is very ironic that the people who are able to access the court and make it possible for Parliament to make these amendments, they are often not the poor people that we are seeking to protect. In conclusion, we want to reiterate that Ultra is rooted in a system based on the primacy of titled private property rights, where the winner is an individual who takes it all. And where Ultra now makes it possible that that winner can also be a woman, it does mean that it remains completely incompatible with indigenous tenure systems, incompatible with rights held.
Ms. Wickham, please switch on your video. It's for the purposes of being live on TV and other social media avenues. All speakers, please keep your videos on, and all other members and guests, please switch off your videos and mute your microphones. Thank you. Proceed.
So the property system that Ultra entrenches is incompatible with indigenous tenure rights, where at household level, people hold rights and in different nesting levels within communities. It also relies on the deeds office system that is unaffordable, inaccessible, and unsustainable. And this speaks to our point that what we really need is a complete overhaul of the tenure system. We want to say that the focus of this committee and the department must be on redefining the tenure system rather than tinkering with a rush job inherited from an apartheid state on the brink. However necessary these amendments are, our submission is they are not sufficient. Thank you, Chair.
Thank you for the presentation. I'm certain that honorable members will have questions of clarity when we get to that. We will move on, honorable members, and take the next presentation, which will be put to us by Mayor Annelise Crosby from Agri-SA.
Good morning, Chairperson, honourable members. Thank you very much for the opportunity. Chairperson, I suspect this committee is doing groundbreaking work with these public hearings that you're having virtually, and I think things are going well so far. But thanks for the opportunity. I hope to save you a little bit of time. I don't have a lengthy presentation. So Agri-SA, for those of you who do not know, is a federal organisation. We're non-profit and we are apolitical, and our mission is to develop a stable and profitable agricultural sector for everybody who wishes to participate in our sector. So we realise fully, Chairperson, that this is a very complex and also a sensitive subject, but one which we think we need to tackle if we want to address food insecurity and poverty, and also development in the areas of application of the Ultra Act. So we believe, Chairperson, and a lot of you who reside in these areas would know this better than I do, but there is a lot of untapped agricultural potential in many of the areas which Ultra applies to. And the unlocking of that potential could have a huge positive impact for the reduction of unemployment, for poverty, and for creating agricultural opportunities in those areas. So therefore, we do believe that it is very important that tenure insecurity should be addressed, and also the lack of collateral in these areas. Because unfortunately, it is exactly this lack of access to production credit that is a major stumbling block in the way of agricultural development in these areas. We fully recognize that there are other factors as well, such as the remoteness of many of these villages, the long distances from markets, poor infrastructure. But if we can address the tenure insecurity and the access to credit aspect, it would unlock a lot of opportunities. So AgriSA has established a small task team which operates under our Land Centre of Excellence to look at how one could open up financing for farmers who are basically farming on state land. And we are looking at various options, but it is very clear that the transferability of rights is a critical component for financing. So therefore, even though we would agree with the previous two organizations who presented that the bill in itself is not the final solution, we do think that this is a step in the right direction. Chairperson, we also want to point out that we, as part of BUSA, we participated in the NEDLAC engagements on this bill, and that we also fully support the submission that BUSA has made during the NEDLAC process, as is recorded in the NEDLAC.
Pardon, Mayor Crosby, pardon me, sorry. Can I please request Serame Ranzo as well as Vivi Hokwana to turn off their videos as they are rendering the video of Ms. Crosby not to be clear. Please switch off your videos and mute your mics. Thank you. Proceed, Ms. Crosby.
Thank you, Chairperson. Chairperson, so AgriSA and its affiliates are already involved in a number of agricultural development projects on state-owned land. Some examples are the projects of the National Wool Growers Association in the Old Transkei, as well as projects of Cotton SA and Grain SA. And AgriSA and its affiliates are quite keen to get involved in more such projects, but the wall that we run against every time is the fact that unfortunately you do need financing for production credit and other kinds of financing, and the lack of collateral is sort of the stumbling block that we run into each and every time. So the shortcomings that we have identified in this Ultra Bill is that and the previous two speakers have alluded to this as well. Ultra has been with us for a long time, ever since 1991. It has not had much impact in the more than 2 decades that it has been in existence. The only way that this is the Ultra Bill in its amended form now is going to make any difference is if in fact it is effectively implemented. So we must ensure that there is effective, dedicated capacity and a real commitment to implementation. Then also we've requested that there should be consideration of mediation in this whole process. And I think that might assist also with some of the concerns raised by the previous two speakers in protecting those existing informal rights, because my sense is that the intention has never been to basically do away with any of those rights. But in order to deal with the aspect of the cost of litigation, the fact that it is so expensive, as well as protecting those rights properly, we are suggesting that an extra step be built into this process, which is the possibility of mediation when a dispute arises. And then we just, in our submission, Chairperson, we also just asked that it should be clear, and this was agreed in NETLAC actually, that the amendment bill only applies to the rights listed in the schedule and not to tenure rights generally. So that has been agreed in NETLAC. I think the department has indicated that that is in fact the intention, but we just want that to be very clear in the bill. And then by way of conclusion, Chairperson, we believe that tenure security preferably in the form of full title, though we recognize that that is not the only way, but that is the preferable form of tenure security is what is required to fully unlock the agricultural potential in the areas listed in the schedules to ultra. We believe that effective implementation will be a key to success, and we are of the view that all land reform beneficiaries should have the option, whether as individuals or as groups, to get full title to the land that is awarded to them. Thank you very much, Chairperson.
Thank you, Mayor Annelise Crosby from Agri-SA. Honorable members, there we have received the submissions from the Land Accountability Resource Center, which was done by Mercy Hlali and Ubau Kanyeza. We also received a submission from Legal Resource Center by Mayor Wincombe. And lastly, the submission by Agri-SA from Mayor Crosby. I will now invite honorable members to put just clear, specific questions of clarity just to gain a more depth understanding. But I will request the presenters to note the questions that have been posed to their presentations and list them down. So then when I afford you a chance, you can then be able to respond to all the questions that were put to you. And I will be able to give 5 minutes to each presenter to attend to the questions that have been put by honorable members. Honorable members, can we have Honorable Klape?
Thanks, Chair. Chair, my network is not at its best. I just have one question on the issue that the bill seeks not to address the issue of communal tenure rights. For sure, our presenters, especially from the Legal Resource Center, they know that there's Communal Land Tenure Rights Act. How do they think we could add up the issue of communal rights in this bill that seeks to do with tenure rights? Thanks.
Thank you, Honorable Klape. Honorable Kapa?
No, thank you, Chair. I have no question at the moment. Thank you very much.
Thank you, Honorable Stein. Steyn.
Thank you, Chairperson. Oh, sorry, Chair. I'm struggling here. Chairperson, thank you for the presentations. I think it's giving us very, very good food for thought. Chair, I would like to find out from the Land Accountability and Research Centers. I like the proposals that you made in your presentation on how do we rather deal with it. My concern was also whether the department and the minister would have the capacity and the resource to deal with this. Would you think that if we call community meetings or public meetings, the disputes would be able to be solved? I think back of what happens when we have community meetings regarding land claims, certain people getting involved in fights, and all of that just takes longer to resolve the issues. So in your view, do you think that would be, and maybe also the Legal Resource Centre might come in into that discussion? Then my last question to the Legal Resource Centre would be specifically about the IPILRA. We listened to the gentleman in the first presentation from KZN, and even under IPILRA and what we have currently in place, communities are being sidelined. Do you think there is something that we could have added in this current legislation that could strengthen the individual or family members' rights under the proposals that we put in place? I'm just worried that if we look at, another piece of legislation that needs to look at communal land tenure rights, it might take another few years and we might see more of this. Thank you.
Thank you, Honorable Matthias.
Thank you, Chairperson. I've got two questions, one for Land and Accountability Research Centre and two for Legal Resource Centre.
Please switch your video on and proceed.
Is on. The thrust of the presentation is on section 19 and 20, which deals respectively with the legal capacity of a tribe to obtain property and the transfer of tribal land to a tribe. I think it was Samora Machel who said, for a nation to be born, a tribe must die. I don't know if they agree with that assertion by the late president of Mozambique, Samora Machel. In their where they come from, what would they prefer to be the case? What should be expressively contained in the final bill and the act? Whether should the land be given to the tribe? And how do we define a tribe in a post-apartheid modern South Africa today? What land administration system would they prefer over what is contained in the act? To Legal Resource Centre, they complain about the bill in its current form as gravely undermining the rights of vulnerable groups, especially women, and denial of property rights and property inheritance rights to women. There are sets of legislations or laws which I describe as stopgap legislative measures. Land Rights Bill 1999, which was never passed, Interim Protection of Informal Land Rights Act, Extension of Security of Tenure Act, Labour Tenants Act, and Communal Land Tenure Rights Act. in their view, these pieces of legislation, have they not been able to close the gap that they have highlighted in the Ultra bill? And if not, what is it that should be done comprehensively to ensure that land rights tenure is secured, and especially for vulnerable groups, especially women? Thank you, Chairperson.
Thank you, Honorable Matias. Can I request all honorable members, when you pose your questions, to please switch on your video for the purposes of being live on TV. Can we have Honorable Priet?
Thank you, Chairperson. I am covered by the other speakers. Thank you.
Thank you. Ndabezitha, Nkosi enkulu, Honorable Cebekhulu.
Thank you, Chairperson. Unfortunately, Chairperson, I've been struggling to connect until about 11:15, I think. It was quarter to 10. So I've missed the first presentation. I only had to switch on the 408 channel just to hear what the presenter was saying. But maybe in bringing both the first and second presenters, Chairperson, I just wanted to ask one question. When they talk of that individual title whole system, what is their view with regards to the large families, more especially in communal land, where you have a family sharing fields in order for them to support and feed the family? How do they think the land should be handled in such instances where large families are sharing a portion of fields where they assist themselves? Could that mean that those fields could maybe be allocated to one a married couple, which is a man and a woman in a large family? That would be my question, Chairperson. Thank you.
Thank you, Honorable Mahlati. Ma'am Mahlati. Honorable
Chair.
Oh, yes, please go ahead.
No, Chair, I think I must indicate we've gotten a connectivity challenges here in the Free State. I will not be able to switch on my video. Okay. Chair, I think I'm covered by the latter speakers in terms of questions. Thank you very much.
Thank you. Honorable Mahlo. Honorable Mahlo.
Hello?
Yes.
Yes, Chair, can you hear me?
Yes, we can hear you, Honorable Mahlo. Please proceed.
Thank you very much. I have a question which it was a question that is related to LARC. How do they propose that the bill should address the issue of conversion of land rights, landholder rights into the full ownership? That is the only question, Chair. Otherwise, I'm covered by other members who have already asked questions. Thank you.
Thank you, Honorable Mahlo. And we have Honorable Chwete.
Thank you, Chair. Chairperson, I'm covered by the latter speakers. Thank you.
Thank you. Honorable Mbabama.
Thank you very much, Chair. I'd really like to congratulate the speakers who have presented here, the presenters. I think they've really applied their minds to the work at hand. I just have, it's not a question really, but it's a request of Ms. Wickham. She says that she implores the committee not to make section 19 and 20 applicable across South Africa without the tenure reform legislation the department is working on.
Please
Annette,
request.
please mute.
Sorry, Babama. Can I request honorable members to mute your microphones? Honorable Stein, please mute your microphone as well as switch off your video. And everyone else, please mute your microphones. Qhubeka, Mam Babam.
Enkosi sihlalo ngaphambili. Ms. Wickham implores the committee not to make section 19 and 20 applicable across South Africa without the tenure reform legislation the department is working on being completed. If she doesn't mind, could she please repeat what she said around this? I would just like her to clarify what she said around this. Thank you very much.
Honorable Masipa.
Thanks, Chair. Chair, I think some of the areas have been covered. I just want to really first thanks the presenters. The point I just want clarity on or assistance with is from the Land Accountability Resource Center. Mrs. Klali indicates that the bill has got no details, clear guidelines, timelines, and obviously permissible constitutional process. The question I have, the request is that can the LARC assist the committee in terms of providing what their views are with regards to the kind of process and the kind of details that they will really require in this particular bill. And basically, there is a question of deliberate approach to provide access towards the information and the support by those that are affected by this particular bill. I think the request from my side is that if they can really provide us, or if they are willing to assist the members of parliament in finalizing this particular bill, we'll appreciate that. Thanks, Chair.
Thank you, Honorable Masipa, and we have Honorable Montwedi. Have you been able to join us? Honorable Montwedi. Honorable Mbata. Is there any other honorable members that we have missed out? Okay, let us proceed then and hand over to our presenters. And as I said, we will afford you 5 minutes to attend to the questions as put to you. I would therefore ask our first presenters, Mesihlali Notatu Kanyeza, to please respond to the questions posed to them. You may proceed.
Thank you, Chair. I think I'll be answering a majority of the questions, and thank you so much to the members of Parliament for their very, very engaging questions. I mean, in terms of what Honorable Klape asked, especially when she said, how can the communal land tenure bill be included, sort of the recognition of those rights be included in ULTRA. And the way that we see it, the amendment process needs to be extended to deal with the practical implications of the bill on communal land. Even if the intention is not to deal with communal land, the practical implication is that Section 19 and 20 do have incredibly dire consequences of for communal rights. So if we're extending Section 3 and opening Section 19 and 20, we are mirroring what the Communal Land Tenure Bill wants to do. So the department did present earlier this year that they want to do a whole land tenure framework reform. So if this is the intention, I know that with what has happened with the pandemic, it has stalled a lot of their plans, because I think majority of what was meant to be achieved was supposed to be done by June. But what we need to see is how these all these different bills speak to each other, because we have the TKLB, which is currently a TKLA right now, and we have a problem with Clause 24. And then we have a problem with the CPA Amendment Bill, because what Ultra seeks to do is give exclusive ownership to one person. So if you are transferring exclusive ownership or giving title to a tribe, obviously you have three sort of landholding entities that can hold the title deed. It can either be a CPA, it can either be a trust, or it can be a traditional council. The most senior person of each of these landholding entities is whose name this title deed would be vested in. So again, what we are emphasizing is you are ignoring community, family, and individual rights by giving exclusive ownership to one person. If I can give you an example of one of our community members who contacted us from KZN, he said to us, the community has agreed to build a police station on his land. All the departments were engaged with, and then he just found the construction has already occurred. He was at a meeting where majority of the community agreed that this land, that a police station will be built on his land. This is in terms of Ultra. Ultra says all you need is a community resolution where majority of the people agree that the land right will be disposed. Now, if we don't understand that he has individual rights and he can say no, especially if it's on family land, then he will be ignored because the majority has agreed. If he seeks recourse using the Communal Land Tenure Bill, he will also face this problem because it requires 60% of households to sort of agree to dispose of a land right. Now, when he brought this up to the community, he said, no, but you're building on my land. I don't want this. I haven't been consulted. I haven't given consent. And even compensation, I haven't been compensated for the land. So in considering those factors, the community said, but we need the crime. We have a crime issue here in the community. So you must give up that land. So that's our issue basically at the core. And with what Honorable Clapper was putting forward is how then do we deal with informal land rights that are recognized by IPILRA? IPILRA itself has not been made permanent since 1994. So that's another thing that the department also has to deal with because the department deals with land reform. So part of land reform is dealing with laws such as IPILRA. So even if we want to move forward with... okay. And I just wanted to say that I feel like I haven't answered majority of the questions, but a comprehensive tenure reform process is needed that properly recognizes and protects individual and family and community rights that respect customary law and rights held in customary law. So this is what sort of my concluding remark when it comes to Ultra is let's go back to what customary law is saying on communal land. And just to say, communal does not mean collective. There are individual, family, community, and village level rights that we need to consider, that we cannot just put tenure or sort of give title to one person, again, because we're going to be recreating the problems we want to avoid. Thank you, Chair.
Thank you, Mr. Tlali. And we have the next presenter, Mayor Wincombe, respond to the questions.
Thank you, Chair. Now, I will do my best in the time allowed. So just following on perhaps on what Locke has said, Ultra as legislation is based on a property regime which sees ownership as the gold standard of tenure, and all other forms of tenure reform are therefore insecure. Ownership is a title deed in the name of one person or one entity. So Ultra can only deal with individuals. So in this case, Ultra has amended to say that individual doesn't need to be just a man, it can also be a woman. Or it can deal with one entity. So as the Act says, a tribe, right? So the committee is asking the right questions. What about family rights, where a family has rights to a field, and within the family, different people have different rights? And the question is, how can Ultra deal with that? In our view, Ultra cannot deal with recognizing the complexity of indigenous tenure rights, because that kind of tenure right is completely out of step with this model that Ultra is imposing upon communities, whereby there can only be winner-takes-all private property in the name of one person or one entity. And so Ultra itself, we don't think this is where that tenure reform should happen. It requires an overhaul of the system, which recognizes that the idea that ownership can only be a title deed and everything else is insecure, that entire model must be overhauled, because it is not it cannot be effectively imposed on indigenous tenure systems in South Africa. So what should the okay, so that's why sections 19 and 20, which places this individual title deed ownership on one entity, a community, that renders all the other rights inside that community insecure, because it is based on this common law Roman Dutch model of ownership. And so that's why we think sections 19 and 20 should not become applicable. It will make people's rights more insecure. What can the committee do? So as we say, number one, section 25A should not make 19 and 20 applicable. And secondly, I think what the committee can do or recommend to be done urgently is for IPILRA, the interim protection of informal land rights, to be made permanent, A, because it is still not permanent, and two, for regulations to be adopted. Because that is the piece of legislation that is helping families to secure their rights. Not very effectively, because it is not permanent and because there are no regulations. So that is something that can be done in the short term as we wait for comprehensive tenure reform. There was a question. Someone asked, how should this bill deal with communal rights? I don't think it is our submission that Ultra cannot deal with communal rights, as in different indigenous tenure forms, because it is based on a private property model. And there was a question about, can communities, will it work to go to communities and ask about tenure rights? Well, remember, Ultra deals with individual rights within, individual rights. So one person, whether it should go to the brother or the sister. So it's at a very localized level. It does not deal with communal tenure at all. And we shouldn't try to make communal tenure properly happen in this bill or in Ultra, because it is simply not designed to deal with indigenous tenure reform. Thank you, Chair.
Thank you. Can we proceed to Mac Crosby and ask Honorable Mbabama, please switch off your microphone.
Yeah, Chair, there were no questions directed at Agri-SA specifically, but as I said at the outset, Ultra is a part of the solution. It can never be the total solution, and I would agree that there needs to be alignment with IPILRA, that we need to respect those existing rights, but at the same time, we need to start unlocking the opportunities. And we need to look broader also than just title and collateral. There are models like crop receipts, which is used in Brazil for financing, but you need to create a whole system to manage that. So we really need to start thinking holistically and out of the box. But this is a first step in the right direction as far as we're concerned.
Thank you, Mac Crosby. Honorable members, thank you for your questions of clarity, which have been responded to by the former presenters. We will move on to the next set of presentations, which I would at this juncture like to welcome all the traditional leaders that have joined us and have been with us on these public hearings. That being His Royal Highness Nkosi Mahlangu from the National House of Traditional Leaders, His Royal Highness Nkosi Mwelo Nonkonyane from Contralesa, and all other traditional leaders that are with us. You are welcome. Let us then proceed, honorable members. We will have 3 presentations from the Commission on Gender Equality, CGE, which will be presented by Mayor van Niekerk. Then we will have a presentation from the National House of Traditional Leaders done by His Royal Highness Nkosi Mahlangu. Then we will have a presentation from Ngonyama Trust Board by the chairperson of the ITB, Ubau Judge Ngwenya. Then we will have a submission from Contralesa, which will be done by His Royal Highness Hosi Mahumani, as well as His Royal Highness Nkosi Mwelo Nonkonyane. We will then take the first presentation from CGE, the Commission on Gender Equality, done by Ms. van Niekerk. Please proceed. You have 20 minutes.
Good morning to you, Honorable Chairperson, and good morning to the members present. My name is Tamara Matebula. I'm not Ms. van Niekerk. Ms. van Niekerk will join me in the presentation. I am the current chairperson of the Commission for Gender Equality, and Ms. van Niekerk is the senior legal advisor who will be doing the rest of the presentation. So I greet you all, Honorable Chairperson, and thank you very much for the opportunity. And thank you for the invite to come and present and appear before you this morning. Thank you very much for this opportunity. I will do the first few slides and I will hand over to Ms. van Niekerk to do the rest of the presentation. Honorable Chair, we come from the Commission for Gender Equality, which is one of the Chapter 9 institutions that is supporting constitutional democracy. Our mandate is drawn from Section 187, subsection 1. And our mandate basically is about promoting respect for gender equality, the protection and the development, as well as attainment of gender equality in the country. We further take our mandate, Honorable Chair, from the CGE Act number 39 of 1996 as amended. It gives us power to monitor, to do investigations, to conduct research, to do public education, lobby and advise Parliament, as well as report on issues concerning gender equality. We basically monitor compliance with regional as well as international treaties that we have signed as the country. Honorable members, we have a vision, a long-term vision of a free society, free from all forms of gender oppression and inequality. I will jump through the slide on mission, and I will just basically introduce why the Commission is basically interested in the issue at hand. The Commission basically welcomes this opportunity to make oral submission to the Portfolio Committee on Agriculture, Land Reform and Rural Development on the upgrading of land tenure right amendment bill. And the CGE welcomes the Department of Agriculture, Land Reform and Rural Development's introduction of the Land Tenure Rights Amendment Bill, which aims to bring the upgrading of land tenure rights, Act 112 of 1991. And this is basically in line with the judgment and order of the Constitutional Court in Rahube versus Rahube and others. The judgment in Rahube and others affirms the equality and alignment in terms of dignity of rights of Black African women, and it reiterates the intrinsic link between property ownership as well as access to housing on the one hand, and it also gives right to equality and dignity on the other hand. The court then expressly recognized its obligation to establish whether enough has been done to eradicate the discriminations that continue and the inequalities that we continue to see that so many women face daily, and found that laws and policies in this country must seek to do more than merely regulate formalistically. The legislature, the court found that it's enjoined to ensure that laws and policies promote the participation of women in social, economic, as well as political spheres, whilst also advancing the spirit, purport, and objects of the Constitution. The question then becomes whether the bill meets not only the requirements of the order of court, but also successfully promotes women's participation in social, economic, as well as political sphere. At this point, I would like to hand over to my colleague, Marisa van Niekerk, to take the rest of the presentation. Over to you, Marisa, and thank you very much, Honorable Chair.
Thank you, Chairperson. Thank you, Honorable Chair and Honorable Members. If we look at the bill, clause 1 of the bill, it is observed that in terms of the court order, the legislature is charged with creating a constitutionally permissible procedure for the determination of rights of ownership and occupation of land to cure the constitutional invalidity of the provisions of Section 2.1. CGE supports...
Please switch on your video. Please switch on your video.
Here we go. Is that better, Chair?
Thank you.
CGE supports the proposed substitution of the heading of Section 2 of the Act, which makes it clear that the conversion of land tenure rights can no longer happen automatically, but must instead be achieved through an application process. The CGE also supports the express mention of those persons who could have been a holder of land tenure rights had it not been for laws and practices that unfairly discriminated against such persons. However, the Commission submits that the proposed insertion of Section 1A constitutes the kind of formalistic regulations against which the Constitutional Court has cautioned in its judgment. Specifically, the legislative proposal of publishing a notice of application in the Government Gazette does not necessarily constitute the kind of notice that ordinary people in South Africa would routinely encounter or access. We therefore submit that the Government Gazette is not a suitable way to provide the critical notice that will significantly affect people's lives, particularly the lives of Black women. It is not available widely enough in the everyday environment, nor is it written in a manner that is accessible and easy for the intended audience. If we look at specifically rural areas, that is more or less where we come from, is to say that our people in the rural areas do not have access to the Government Gazette. In terms of our rural Black women, who are even less likely than urban women to have access to legal advice and assistance, or even a public library, which is one of the few places where the Government Gazette can be accessed physically on request. The Gazette is almost exclusively in the purview of legal professionals, academics, and government officials. To publish a notice of application in terms of the bill in the Gazette will only lead to such notices being missed by those most affected and those who would most need an opportunity to object to a conversion. The notification system will fail to promote the participation of women in social, economic, and political spheres, while also advancing the spirit, purport, and objects of the Constitution. It would honour the Constitutional Court's order in form alone, but not in any substance. And the very women who are intended to benefit from the bill will only continue to be excluded from the benefit of the new law. If we look at alternative ways of providing the public notice of an application for conversion of rights, we urge the department and the committee to explore alternative ways of giving this public notice of an application for the conversion of tenure rights into ownership rights that take into account the manner in which information is most commonly communicated and accessed in this time. These alternative methods will then also include national, provincial, and most importantly, local print media, like your local newspapers, electronic media, government websites, social media such as Facebook and Twitter, which could prompt users to click through to a notice. If we then look at clause 3 of the bill, while CGE supports provision for aggrieved parties to approach civil courts in section 14A1, we wish to remind the committee and the department that access to legal representation, which would presumably be required in a formal court hearing in civil law matters, is extremely rare for those who cannot afford private legal services. This is doubly true for Black African women in South Africa who bear the overwhelming brunt of poverty, with an expanded unemployment rate of over 43.2%. Additionally, when women are gainfully employed, they earn considerably less than men. We all know that the gender pay gap is still a reality in the country. This trend becomes exacerbated by women's age, with women between the ages of 45 and 54 earning only 61% of what men earn, and women ages 55 to 64 only earning 61% of what the men earn. Legal Aid Board of South Africa allocates the vast majority of its budgets to criminal representation in accordance with its constitutional mandate. It means that there's very little that remains for free legal representation in civil matters of any kind, and the already small amount must be divided between vulnerable groups, including children. By way of illustration, in its annual report of 2018-19, Legal Aid Board allocated 1.2 billion for criminal matters, but only 148 million for free legal representation in civil matters. So there's quite a big difference in the amounts. Non-government legal centers and organizations tend to focus only on impact litigation and specialized legal advice due to limitation of donor funds. And we also know that donors, when doing funding, also then stipulates which types of litigation may be undertaken. University clinics also have limited resources. Applications for pro bono services provided through Legal Practice Council are allocated a means test, and that leads then to the missing middle, where people earning more than 7,000 Rand gross monthly income will not be able to utilize pro bono services. In the circumstances, I think we should remember that Black African women will not be easily able to enforce their rights in the manner envisaged in this bill. And for this reason, the Commission then submits that if a woman is aggrieved by land rights conversion, if they can only have a recourse through the civil courts, it may constitute yet another real-world barrier to fair access land and housing. Instead, the Commission then submits that the administrative appeal process through the department may present a better opportunity for women to exercise their rights in constitutional rights, or for their rights in this context. Access to civil courts is still a possibility in accordance with the constitutional right to administrative justice, and once an internal appeal process is exhausted, it will no longer be the first and only port of call for an aggrieved party who cannot afford legal representation, and then obviously the PAJA processes will follow. In this regard, CGE would like to express its thanks to the Portfolio Committee for the opportunity to make the oral representations of the bill. Thank you, Chairperson.
Thank you for the presentation from CGE, Commission on Gender Equality. Honorable members, we will move straight on to the next presentation, which will be put to us by the National House of Traditional Leaders, His Royal Highness Nkosi Mahlangu.
Thank you, Honorable Chair Ndabezitha Nkosi Mandela Bayet, and also greetings to the rest of the members of the committee, the Deputy Chairperson of the National House, who is also with us, and Nkosi Kazi Ngonyama, and the CEO of the National House, members of Contralesa, the executive of Contralesa that is also part of those that will be presenting, and all other groups that are part of us today. As the National House, we firstly want to appreciate the opportunity that has been given to us to also participate in this process, where we input on this very important bill that is currently before us. I think what we thought we need to take into cognizance, is that firstly, as the House of Traditional Leaders, we are representing the institution of traditional leadership. That institution of traditional leadership has traditional leaders that are representing communities, and we are representing communities as a whole, not individuals. And I believe that African communities have been built through communalism. So whatever that we do it as communities, we do it as families. And even when we look at the issue of land, we look at it from a communal perspective, and also from a perspective that the land that we allocate as a sector, we allocate to families. Secondly, what we also need to be mindful of is that as the institution of traditional leaders, we are part of a process that seeks to look at the land tenure system as a whole, not necessarily with looking at different parts of the tenure system like this legislation. So there's a process that is currently underway that is being led by the Department of Rural Development, and I think this committee is also part of that process. So that process is currently underway, and of which I think it's a process that we are looking forward to making proper inputs on how tenure system in the country should be. Thirdly, Chair, I think the timing of this bill has also been very challenging. I think we are well aware that we are currently in the midst of a pandemic where people have been working from home, and most of the sector is in deep rural areas, and in most cases where you can't even get the views of the whole sector. And I think in the light of what I have just said, Chair, that the National House, the inputs that we make are not necessarily our inputs as the National House, but it is the views of the sector that we're supposed to get from the majority members of the sector. And I don't want to lie, Chair, and say that the document that is before you is a document that represents the whole institution, because we have not been able to properly get the views of the sector due to the challenges that I've just highlighted on the during the period that we find ourselves in, and also the issue of technological problems that we had to encounter. So I would want to request, Chair, that we be given an opportunity to withdraw the document that we've submitted, because we believe that it is a document that has been done for purposes of compliance, but it is not necessarily the full views of the sector, and we do not think that it will assist this process if we have not been able to thoroughly engage with the document. I'm happy now that we've moved to the next level, and I think as a sector, if the committee does allow us to resubmit, we'll do so. If not, I think we'll participate in the public hearings that will be conducted, where we would have thoroughly engaged with the bill. But suffice to say, Chair, that those that have engaged with the bill, I think the majority of the members feel that this bill will take us forward. It seeks to address the serious challenge of discrimination against our women, of which as a sector we are working hard to try and correct and make sure that our women are also getting the same benefits as everybody else throughout the country. I would, with the mandate that have been given by the committee or the collective that is currently represented here, request that we withdraw our our written presentation so that we can get more views from the sector, because we feel that we are not assisting the committee enough with the document that we have presented, because it does not cover what we thought it should cover. Thank you, Chair.
Thank you, Your Royal Highness Nkosi Mahlangu, the chairperson of the National House of Traditional Leaders. We will now proceed to the presentation by Ngonyama Trust Board, which will be done by the chairperson, Ubauta Jungwenya. Please proceed.
Thank you, Chairperson, and good morning to you, sir, Nkosi Mandela, the members of your committee, and all participants in this exercise. I hope you can hear me, Chairperson.
Yes, we can hear you loud and clear. See?
Thank you.
And do switch on your video for the purposes of being live on TV.
I have to look for the video. Yeah. Thank you, Chairperson.
Thank you.
Chairperson, I'll give just a brief background of our presentation and then touch on the matters that we feel that are germane to today's presentation. The deadline that originally was published was the 31st of July. We made a preliminary submission, but we asked for extension, which was granted until the 15th last week. We're then able to provide a supplementary written submission on the 13th. We just want to emphasize a few things, Chairperson. The bill as it stands, it would seem to us that it goes slightly beyond what the issues were and what the constitutional judgment says. The section that was impugned in the bill, in the Act, was Section 2, subsection 1 of the Upgrade of Land Tenure Rights Act 112 of 1991. That's the section which was declared unconstitutional, and the court made that order retrospective to 27 April 1994, in other words, on the dawn of democracy. If one looks at the bill, the objects of the bill now are, which is in compliance with, which is an attempt to comply with the court order, among others, is that the bill seeks to provide for the application of conversion of land tenure rights to ownership. This is where we believe the problem starts, because the Act already provides for that. Unless the bill says there are other mechanisms, we believe that that has strained the bill, and as a result, it now wants to provide for other things. In particular, the issue of, which is stated in the background, paragraph 1.2J. The bill now includes, in other words, seeks to extend the application of the Act to any right to the occupation of tribal land granted under the indigenous law or customs of the tribe in question. We believe that that is taking the bill too far, and that a tribal law, of which among others including Ngonyama trust-owned land, should not be part of this exercise. Like other speakers and commentators have said, indigenous customary law is complex on its own. It requires a dedicated attention. Now, if it is now introduced via kind of backdoor of this bill, it will do more damage than good. We also draw your attention, Chairperson and members, that the writers of the bill, in particular the department and the senior state law advisor, admit that they did not consult while on the bill. They state that they only have consulted with other state departments. In our view, this is fundamental to this bill, because consultation has become...
My apologies,
Yes,
Bangwe. Can you please ask the members of the ITB to not walk behind you as they are helping themselves to tea, rather to walk in the front on the other side, because we are live on TV and they are visible on the camera.
Thank you very much, Chairperson. My apologies for that.
Thank you.
We are saying, Chairperson and members, the flaw in the bill already is that it has not been consulted. In other words, the beneficiaries of the bill, who are intended to be assisted by the bill itself, have not been consulted. What is stated here is that the department and the state law advisors are of the considered view that the provisions of the bill, once enacted into law, will then be communicated to all institutions. They refer to institutions that will be affected by the implementation of the Act. Our view is that the law is not only for institutions, but is for all people. And therefore, in this regard, we believe more needs to be done with the bill. We are fully aware, Chairperson, that the deadline set by the Constitutional Court, which was 18 months, is now looming. That said, though, we believe that in providing for a mechanism that would allow a due process whenever an upgrade of a tenure right on surveyed land, as the Act has stated since its inception. In our view, the Act, and therefore the bill, was geared and earmarked for urban land and mainly for individuals who own land as individuals in urban environment. We believe, therefore, that there are a number of flaws to the extent that it extends to tribal land. One is that we have not seen any communication of this bill in any of the indigenous languages. I think one can accept that the victims of apartheid, for purposes of what we are discussing here, would mainly be Africans. Now that the bill is communicating in English, everything is in English, and the disadvantaged people are mainly people who would not ordinarily read formal documents like the adverts in the newspapers and who have the understanding of participating in these public hearings. Makes it worse that the bill could be proceeded with in that regard. We are proposing that in providing for a due process, there are two kinds of possible situation where the process is required. The first is an instance where the individual has already benefited in terms of the impugned provisions of Section 2.1, simply because the bill is retrospective to the 27th April 1994. It means those individuals' benefits in terms of the impugned provision will now be subject to review. And we believe that must be clear how that process will take place. In other words, to consider a person who acquired and upgraded tenure rights on land on the basis of an automatic application of the Act. On the other hand, we're talking about people who still need to face the application of the law as shall have been amended. In other words, whereby all affected people will have to be notified and invited to participate in the upgrade process. We don't seem to find it well spelled out in the bill as it currently stands. However, we want to emphasize that that could be improved upon without delay, but more importantly, that the section I referred to in 1.2J need to be removed completely so that it is clear that this bill does not get extended to tribal land anywhere in the country. A different process, we believe, is underway and will be underway. That will enable rural Africans on tribal land to state their case. In particular, we are submitting that the African woman, especially in rural area, must have her day, her voice must be heard, not through representatives, not through NGOs only, but also has a voice because the rights there under the traditional system are intertwined. And also there is a layer of rights, not only rights to land standing alone, corporate in some instances, religious and economic rights. So if these are not recognized now by virtue of taking customary law as a footnote to the South African law, that would be the worst legacy that the democratic state shall have bequeathed to the African woman who has for years been at the receiving end. So in conclusion, Chairperson, our recommendation in a nutshell is that Section 1.2 brackets J of the Memorandum of the Amendment Bill, which reads as follows: any right to the occupation of tribal land granted under indigenous law and custom of the tribe in question be removed from the bill, and that the bill make it clear that it does not apply to land currently administered in terms of customary law. And furthermore, that the procedure for due process be clearly spelled out and elaborated upon. Thank you.
Thank you, Bao Judge Ngwenya from Ngwenyama Trust Board for the presentation. Honorable members, let us just take note that the bill can only be translated to other languages, all official languages, once it has become the law. However, we do have the memorandum of the bill, which has been translated in all languages in our endeavor to meet the expectation of the public. But also, let me highlight, honorable members, that the communications team made all necessary arrangements to reach out to radio stations, particularly vernacular radio stations, to ensure that our people in rural areas were able to be invited to these public hearings. We will now move on to the next submission made by the Congress of Traditional Leaders in South Africa. That is His Royal Highness Hosi Mahumani, as well as Nkosi Mwelo Nonkonyane. You may please present. Contralesa Hosi Mahumani, Nkosi Nonkonyane. And Secretariat confirm if they are indeed part of the listed participants on our participants list, because I don't see their names. Maybe they have not linked in.
Chair?
Yes.
I did not get that one. What were you saying, Chair?
No, I wanted you to confirm on the participants list if Contralesa is present. Have they been able to link? Because I don't see their names, and we have called on them to present, but we seem to not get them on board.
Okay, Chair, we can continue with the next presenter. I will, in the meantime, speak to Mr. Mkiva and check with him.
Okay, that was the last presentation, honorable members. We will therefore, in the absence of Contralesa, proceed to questions of clarity on the three presentations that have been put to us. And I will therefore request, honorable members, that you be brief and very spot on the questions of clarity. And I'll again request our presenters to list down their questions as they come, as they are put to them, and be able at the end to answer the questions. I will allocate 5 minutes to each presenter to engage with the questions. We'll move on then to honorable members, and please switch on your video when you're posing your questions. Honorable Klape. Klape. Honorable Kapa.
Thank you, Chair. Don't have any question at the moment, Chair. Thank you very much.
Thank you. Honorable Stein.
Chairperson, firstly, Chair, thank you for the presentations and especially the information that was provided to us by the Commission of Gender Equality. I think it is very important, especially after what we heard this morning regarding access to courts, access to make sure that women are being represented. Chair, I think it gives us some very good background. Chairperson, my question to all the presentations, and I think the Commission of Gender Equality specifically made reference to that, but what would they like to see in this piece of legislation to ensure that we strengthen the rights of women specifically? I think it's going to be quite difficult for the last two presentations from the Ingonyama Trust Board and from the National House of Traditional Leaders to give us some kind of indication of currently the processes being followed under traditional leadership. What rights would women be having if we want to strengthen women's rights under the current traditional ways of doing. So if you would like to make a proposal for us to look at strengthening women's rights on communal land, what would that be? Thank you, Chair.
Thank you, Ms. Stein. And we have Honorable Ntate Matthias. Ntate Matthias. Honorable Priet.
Thank you, Chairperson. I want to agree with Honourable Stein, and that was going to be my question as well. Specifically, I enjoyed, or not enjoyed, but I heard what the CGE was saying, and that was my fear as well, was specifically taking into account traditional rights as they are. That we can have legislation there, like Ultra, to give women more rights, but in a traditional context of the word, we would still be, women will still be at a disadvantage. And I don't think I can word it any better than Honourable Stein in terms of what are we envisioning, what specifically in terms of ITB and the National House of Traditional Leaders, how will we give women more rights? How would we find that balance between our traditional houses, traditional cultures, but yet taking Ultra into account, and how to give our women true rights and power and ownership of land. Thank you, Chairperson.
Thank you, Honorable Brett. Honorable Ndabezitha Kosi Cebekhulu.
Thank you, Chairperson. I don't have a question or a comment on the two presentations that have been made so far. Thank you.
Thank you, Ndabezitha. Honorable Masipa. Honorable Masipa.
Thank you, Chair. Thank you, Chair. I just want to say thank you to the presenters. To the presenters that just made their presentation. I could only hear the ITB present. I think my question, Chair, with regards to ITB presentation is obviously there is a recommendation that we must remove section 1.2, that any right of to the tribal land be affected by this particular bill. I think the question for me is that isn't it premature for the ITB to indicate that while they are also recommending that, there must be inclusive participation and obviously recommending that indigenous language be used to engage the communities. So my question is, wouldn't it be premature for them to ask that this be removed instead of waiting until the public participation is done and consultation is done, and obviously hearing the views of the people and take it from there in terms of the decision going forward in formulating this particular bill? Thanks, Chair.
Thank you, Honorable Sipa. And we have the Honorable Mahlati. Honorable Mahlati. Honorable Mbabama.
Thank you, Chair. I am covered by my colleagues. No questions from me.
Thank you. Any other honorable member that would like to pose a question? Honorable Mahlo.
Honorable Chair, thank you very much. Hello.
Please switch video.
Honorable Chair.
Yes, please switch on your video. Thank you, Ma'am Mahlo. Proceed.
Okay, thank you. I do have some few questions which I want them to be clarified. Let me start by saying that it's our Women's Month. The August month is our Women's Month. We are happy that the gender equality is part of us. How do you, the Gender Equality Commission, how do you envisage the amendments to the Ultra Bill could be crafted in order to secure land ownership by urban women? That is something that I wanted to understand. We all know that, Chairperson, that there are vested and conflicting interests by family members on one land or property. Since many of our people do not leave valid written wills behind or PTOs in Black Townships area, did not translate the full ownership of the land by the Black occupants. Furthermore, Chairperson, given the fact that customary law is not applicable in urban areas, what form of module of land tenure rise do you think will be the best to secure women's ownership of the land in both rural and urban areas? And have you conducted case study on land tenure module, drawing lessons from that? That can be the best benefit for majority of our women. Thank you very much.
Thank you, Honorable Mahlo. Is there any other honorable member that I've missed who would like to pose a question? Thank you, honorable members, for your questions of clarity. We will now move to answers on those questions. I will therefore give the platform to CGE, Chairperson and the Legal Advisor. Mayor Tamara, please proceed. Mayor Mahlo, you can switch off your video and mute your microphone, please.
Thank you.
Mayor Tamara.
Thank you,
Honorable.
Thank you,
CGE.
Honorable Chairperson. Am I audible, Honorable Chair?
Yes, yes, you are audible and visible. Thank you. Please proceed.
Thank you. Thank you very much, Honorable Chairperson. And I want to thank honorable members who posed questions for CGE to respond to. I will respond to the first question, and Ms. Fanny Kek will respond to the second question. I think the question I will respond to was a question that was asked by Honorable Steyn and Honorable Briet on what is envisaged by CGE to see that women's rights are upheld. Honorable Chair, I want to explain that if you look at generic women's rights, these are the fundamental rights that we talk about generally, which are enshrined not only in our Constitution of the Republic of South Africa, which is very, very important, highest law in the country, but they are generically enshrined in the United Nations documents, and they include, but not limited to, access to own property by women, access to earn and fair wage, access to equal opportunities, free from discriminations, all sorts of discriminations on the basis of gender. So those are the rights that we're talking about. And I think this morning that's the right that we need to actually be looking at in terms of access to land and access to own property by women, particularly Black South African women in this country. So, Chairperson, I just want to say that the Commission, for an example, in 2016, what we did as the Commission for Gender Equality was to actually conceptualize a project, and we consulted quite a lot with people in rural areas, people in semi-urban areas, urban areas, especially women, and we came up with a report on a concept, Honorable Chair, that was talking to 1 woman, 1 hectare of land. And I think in our conceptualization of this 1 woman, 1 hectare of land was a way of actually looking at whether women in South Africa can be given a chance to at least own a hectare of land. I know that a hectare is not a lot, but we thought that at least if we can start piloting this project in South Africa, a woman could actually have the right to own at least a hectare of land. So this concept, Honorable Chairperson, it's a concept that we presented in 2016. It was presented to the Portfolio Committee, the very same Portfolio Committee in 2016. And I think this particular 1 hectare, 1 land concept was then handed over upon discussion with the Portfolio Committee. It was handed over to the Department of Public Works and Department of Rural Development at the time for implementation. And I know that this is a concept that was taken by the department for implementation, Chairperson. I think last year we've been looking back in terms of how far they have gone in terms of implementing the 1 woman, 1 hectare land project. Thank you, Chair. I think that was one of the attempts by CGE just to make sure that women have the right to access a hectare of land. Thank you very much, Chair. Over to you, Marisa.
Thank you, Chairperson and honourable members. Just to add to what my Chairperson Matabula is saying, CGE also has a lot of instances where women are not able to access land due to marital status, for example. So those are some of the cases that we're also looking into, and we are working through courts in terms of that. Now, as some of the members have asked, and I've jotted down, in 2009, CGE did do a study on land. Now, this is something that we took up again, as Chairperson Matabula is saying, in the 1 woman, 1 hectare campaign. But we will, in the next year's APP, see if we can include another study on land specifically, as there's a lot of movement and involvements as we go along. In terms of the tenure rights in urban areas, I'm not sure whether the honourable member refers to land in the rural area, although you stay in the urban area, or whether there are specific urban areas. But as I say, that is something that we will have to look in, and we will probably look into that in the 21-22 APP, as that will be one of our themes that we will then look into take up again. Thanks, Chair.
Thank you, Mamu van Niekerk, as well as Mama Tebola from CGE. The committee will be interested, Mama Tebola, on the list that any data you may have on the One Women, One Household project. We have been in discussion with the Department of Agriculture, Land Reform and Rural Development, as led by the Minister, the Honorable Lumamo Tidiza, who in their One Household, One Hectare project, they've only been able to discharge 1% of their budget. As a committee, we would like to ensure that those funds are utilized in their totality, particularly for rural communities and more so women in particular. So we would appreciate if you could send through the Secretariat the data that you may have in terms of your One Women, One Hectare project, so as we can try and see as to what the department can do in aligning their One Household, One Hectare project with that you have identified. Honorable members, let us proceed to the presentation of the National House of Traditional Leaders, which the submission was made by His Royal Highness Nkosi Mahlangu. Any responses on the questions of clarity or any comment? Ndaba ezitha Nkosi enkulu Mahlangu.
No, thank you, Chair. I think there was a question that was posed to us as traditional leaders. I would first, because I am with my colleagues, with Nkosikazi Mhlawuli, who's the Deputy Chairperson of the National House, and also Nkosikazi Ungonyama, who is chairing the committee that deals with land. Maybe let me share through you, if they could also have a bite to the question. And that question was, what do we envisage as the rights of women, within communal properties? So maybe if they could have a bite, I'll come in as well to assist.
That is it. They may proceed.
I'm waiting for my deputy chairperson.
Can proceed, Nkosi Lukhumbo. I'll be the last.
Oh, thank you. Thank you, Honorable Chairperson of this committee and the session. I greet everyone. Madiba Mhlekazi wami. I think I would like to make it clear, and just to ease members, to put members at ease, to state that the institution of the sector has progressed so much that even in the Act, because we're a country that is led by that operates in terms of the laws, we do also, as the traditional leadership sector, work and we are governed by the Traditional Leadership and Governance Framework Act number of 2009. If you go through the Act, you'll find that even when we talk of royal councils, that is where everything starts, because as we go to the National House, we climb through certain ladders, that is from royal council to local houses, provincial houses, up until we get to the National House. But now I just want to bring to the attention of the members that even in terms of the Act, the section that talks about the number of women who are supposed to form part of the council, it says at least head of the members should be women. That on itself shows how much we are progressing, and we, as the sector, we have embraced that so much. Just to mention a few, Mamumhlawuli is gonna come in after me. She's the deputy chairperson and she's a woman. I am a woman, a regent, senior traditional leader in my own right, leading a council which has got about 16 villages. I am a woman. So I'm trying to paint a picture of saying whatever that people have believed or whatever they've seen happening, they should note that things are changing and they're changing for good. So when we talk of land, as the council, it is not a one-man show. The council takes a decision. Everyone has got a right to approach the council and look for a piece of land to build. Because what is happening now, most women, they give birth without being married. They've got families without being married, and they have to protect and have a shelter for their families. Therefore, it is imperative that as the council or as the councils, we do provide land for those people to stay. But I just want to sensitize members that in every situation and in every sector, there are requirements that one has to meet. You cannot just bounce in a village and claim that because I'm a woman, I'm entitled to get a piece of land. There are certain processes and procedures that one has to follow, because we have to know each and every person that is residing within the village to avoid issues like embracing people that have been chased from their villages and yet they were thieves. There are so many issues, but I just want to emphasize to people that we are embracing the issue of women and they are getting land as and when they require that, having followed the necessary procedures and processes. I also would like to place on record that we cannot shy away and turn a blind eye on few instances where people were not treated good, or they were not treated right in some instances. But I would like us to be cautious of not painting the entire house with one brush. As I've said, that there are isolated incidents, but be that as it may, the women are really, they will take cognizance of their needs. We know exactly what they require and what to do if and when they require the land. Even when it comes to plowing, the one land, 1 hectare, each and every household, when you are given a piece of land to build, the communities also make sure that you get even a piece where you are going, the piece of land that you are going to use in order to produce crops, because you have to eat at the end of the day. Those are the things that are looked into, and they are made sure that we do follow those instances. In fact, we do ensure that people are treated fairly and they are treated equally in as far as the land is concerned. That's my take. Thank you, Chairperson.
Thank you, Madiba, Chairperson, honorable members of the committee, Chairperson of the National House, and other representatives here. Chair, the Ngosi Nopongwa has said it all. The objective of having women in these structures, including the traditional leadership, it is clear that it's for us to advocate for the rights of women. That's why the traditional leadership has identified us as leaders. You can understand that traditional leadership is a male-dominated area, but they did allow us, they did elect us as members so that we achieve what we are talking about here, including our male counterparts. It's not that we are fighting this on our own. The traditional leadership is considering the issue of representative of women and achievements, including the issue of land ownership. Chair, when we're talking about the land, let's remember that we are not talking here about the houses. We are talking about the homesteads. We are talking about the families. Now, when you're talking about one woman must have land, we agree on that one. But when we are talking about what we are saying, we need more women to own land, not only access to land. Access is something else, but ownership is something else. So to own land, we also ask government to give more land to traditional leadership because we don't have enough land to allocate to those women we are talking about. We can try and want to allocate land, but if we don't have enough land, it won't be possible. Also, as it was indicated, that also the issue of the communal values and other values need to be also considered when we are talking about the issue of land. We are here we are supporting as what our own, that we must own land as women, but we advocate for more land, especially for food production, also for sites for women. Thank you, Chair.
Thank you, Chair. Maybe if I may come in, I think as a sector chair, I think we must all appreciate that almost half the country has been confined to about 13% of the land. In fact, it's not even 13%, it's less than 13% of the land. So there's serious congestion in rural areas, and how land has been allocated. We've been focusing mainly on families. I think when one comes to look for land, especially site to build, I think one is always required to come with your partner. If you are a woman, you'd be expected to come with your husband, and if you are a man, you'd be expected to come with your wife. And land will be allocated to that family that is seeking land. But we've realized, I think, as Umama Ungonyama has said, that we are having more women that are not married and that would be looking for a piece of land for their families. And I think we've been granting that land to women, and we also are now also granting land to the youth as well, even for the projects that the youth want to do. And there are also other areas that would demarcate, and those areas will be converted into townships where there is individual titles, where people would get individual titles within a communal space where rezoning has taken place. So I think the sector has moved quite progressively in terms of making sure that women are participating, women are given respect, women have access to land as they should. Yes, it is correct that there may be small pockets of areas where that has not happened, but I think in a traditional setting, it is always known that even you as a husband, if maybe it may happen that you want to marry another woman, you would have to go and build that woman a house somewhere, because the house that you had with your wife belongs to your wife. You know, so you then have to build another house that belongs to that wife that you may have married as your second partner. But I think in the main, it is always known that a household belongs to women. It does not belong to me as a husband in rural settings. And I think that's what has been happening throughout all these years. It's not something new that women have always been owners of their household. That is, in those days, that is attached to that household, but the women have always been the owners of that household. And we are also moving fast in terms of making sure that women participate in leadership positions, even within traditional councils, in deciding how land is allocated. We are all participating with women traditional leaders and members of the community that are women. Thank you, Chair.
Your Royal Highnesses, thank you for answering the question put by the committee. Honorable members, let me Unkoskazi Nobongo says that Ndabezita, you as the National House of Traditional Leaders has seen about 1/3 of women into the structures. We would like to make a calling as the committee that you align yourself to the 50-50 policy that is advocated by government, so that we can have women effectively represented in the National House of Traditional Leaders, particularly living in a country where the majority is made up of women. We would also want, as I sit also in the committee that is dealing with the amendment of Section 25, I hear you are making a calling for more land to be given to traditional leaders, and I think your voice might be better suited to make a calling there in the amendment of Section 25. We would want to make that request that you are able to engage and make your submissions there as well, so that the voice of the traditional leaders is also recorded during those public hearings. I've been able to participate in Mpumalanga, in Northwest, as well as in Gauteng, where we had traditional leaders in those respective provinces come out to participate, and would like to ensure that with the remaining provinces, you are able to mobilize traditional leaders to make their submissions. Thank you for your responses. Let us move to the last presentation, which was made by Ingonyama Trust Board, the Ubao Judge Ngwenya, chairperson of the ITB.
Thank you, Chairperson. I think the questions that I'm responding to are really two, because Honorable Steyn was supported by Honorable Briet, and Honorable Masipa inquired whether our proposal is not premature. Honorable Steyn's question is, what can we recommend to your committee, Chairperson, to help strengthen women's rights to land on traditional land? Firstly, Chair, let me start by saying, like I earlier said in my presentation, the court order which has prompted this process of amendment reads as follows. the order of the constitutional invalidity made by the High Court of South Africa, Gauteng, Pretoria, on 26 September 2017, in respect of Section 2, bracket 1, of the Upgrading of Land Tenure Rights Act 112 of 1991, is confirmed subject to the variation set out in paragraph 2. And paragraph 2 reads as follows: the order of the High Court is varied to read: A. Section 2, bracket 1 of the Upgrading of Land Tenure Rights Act 112 of 1991 is declared constitutionally invalid insofar as it automatically converted holders of any deed of grant or any right of leasehold as defined in Regulation 1 of Chapter 1 of the Regulations for the Administration and Control of Townships in Black Areas, 1962, Proclamation R293, Government Gazette 373 of 16 November 1962, into holders of rights of ownership in violation of women's rights in terms of Section 9(1) of the Constitution. That is all that the court judgment is about. What it seeks to be remedied is that a person who invokes Section 2(1) of the Upgrading of Land Tenure Rights Act shall not get an upgraded tenure rights automatically. And what is important is that these rights are in urban areas. In the main, there could be many of them, but what comes to mind, Chairperson, is what would you get in the form of rights that can be the subject of upgrades. Like in the Rahube judgment, it was what is called a certificate of occupation, or in some parts of the country is called house permits. Or else you may get a PTO, which is a permission to occupy. Or else you may get a deed of grant, or special leasehold rights which were issued under the laws governing Africans. In some areas, which are very small, you may get quit-rent instrument. But all these rights, if you invoke Section 2, bracket 1 of the Upgrade Act, or ultra, they will lead you to one instrument which is called a title deed. The Act itself does not apply to tribal land, and therefore we don't believe we're in a situation where we could offer a useful advice or recommendation to this committee to stretch to tribal land or rural areas where the land is not surveyed, where in the most is held through oral tenure with no documentation. That is my response to the first question. With regards to whether our recommendation is not premature because the process is still unfolding, we're saying this because this is a new addition which was not asked for by the court, and therefore it cannot in any event be implemented because the rights in tribal environment or rural African environment are intertwined, that you cannot extricate one from the other without first starting with a survey. Traditional land generally in South Africa is not surveyed. I think it would be important for the committee to take note that the survey exercise, apart from being lengthy, is also costly. So to that extent, we don't foresee under this process a situation where something more than strengthening the rights that were issued under various legislation in urban environment for Africans, where you can then create new rights that need to be upgraded, as it is implicit in the first question. And therefore, the question is thus not premature, because once the process has concluded, it will not come back and say, there is now an opening for people who say what must be removed. The purpose of this submission is that at the end of the day, as the lawmakers, you will take into account every presentation made and see whether it makes sense and it's practical and implementable. By then, we shall no longer be having this opportunity, and hence our submission. In short, we are saying our submission is not premature. Thank you, Chairperson.
Thank you, Bongwe. And let me also thank the rest of the presenters during this morning's session. Bongwenya and the ITB are adhering to the COVID regulations. But it will be worthy, Bongwenya, to note that when you are wearing a mask, you must wear it fully to cover your mouth and your nose. You are still audible beyond the mask. I will then, honorable members, having dealt with this morning's session, ask that we adjourn for a lunch break, which we will afford you 40 minutes, and we will resume at 12:45 with our program. The meeting stands adjourned. Manyamza, Wamkakas.
Sikhona tata.
Please take note that we have adjourned the meeting for 40 minutes since we have finished the morning session.
Yes,
we will
Chair.
resume again at 12:45. So please alert the IT division
Okay, Chair.
that we will resume again in 40 minutes at 12:45.
Enkosi tata.
Enkosi.
Lo.
Saule.
Bulela mna tata Chapha.
Okay.